Hi, and welcome to another legal English lesson for lawyers. I'm Ted Goodman, and today we're diving into a core professional skill: how to give legal advice clearly, confidently, and in a way your clients can actually understand. Whether you're helping a startup, advising on immigration, or managing litigation, knowing how to explain legal issues in plain, professional English is key. Let's take a quick look at what we'll cover in today's lesson. First, we'll explore some of the most common phrases lawyers use when advising clients. These expressions will help you sound professional but approachable. Second, we'll use modal verbs like should, might, and must so you can offer legal recommendations clearly and accurately. Third, we'll look at some polite legal idioms that can help you soften your tone when necessary, especially when discussing risks and obligations. And finally, you'll be practicing responding to a common client questions using professional language that builds trust. And by the end of this lesson, you'll be much more confident speaking with clients, whether you're in a call, writing an email, or meeting face to face. Let's start with a warm up to get you thinking. What do clients really expect when they come to a lawyer for advice? In most cases, they're not looking for complicated legal theory or overly technical language. They want clear, helpful guidance. Let's break it down. First, honesty and clarity. Clients need to trust you. They appreciate it when you explain things in plain English. No jargon, no legalese, no confusion. Second, they want a step by step explanation. The legal process can be overwhelming. When you guide them through it clearly, you build confidence and reduce stress. Third, clients want to know their options. What choices do they have? What are the risks? And what might happen next? Giving them realistic outcomes helps them make smart decisions. So take a moment now, if you want to pause the video and think about your own experience. What kind of expectations do your clients usually have when they meet with you? You can write a few ideas down, then hit play when you're ready to continue. Let's begin looking into some vocabulary. Let's start with the verb counsel. In legal English, to counsel someone means to give advice, formally and professionally. Instead of saying, I give advice to clients, you might say, I counsel clients on their legal rights. It's a more precise, professional sounding verb that shows you're speaking in a legal context. For example, our firm counsels startups on regulatory compliance. Try using this in a sentence about your own work. How do you counsel clients? Next up is a key legal term: legal standing. This means a person has the right to bring a case to court, that they're directly affected by the issue. For example, we could say the plaintiff had no legal standing to sue. That means the courts didn't recognize their right to take legal action. No standing, no case. You'll hear this term often when discussing access to justice or procedural issues. Let's talk about a very important word: liability. It's a word you'll use often in civil law. Liability means legal responsibility. If someone is liable, they're legally at fault. An example: the company accepted liability for the damage. This shows up frequently in lawsuits, insurance claims, and tort law. Keep it in mind anytime you're discussing who's responsible for harm or loss. In common law systems like the United States and UK, precedent is a big deal. It means a prior court decision that sets the standard for future cases. Judges often say things like, we followed precedent from an earlier case. Using precedent helps keep legal decisions consistent and fair. When advising clients, it's helpful to explain how past cases can affect their outcome. Compliance. Compliance is all about following the rules. In legal terms, it means obeying laws, policies, or official procedures, especially in business and regulatory law. For example, the company was in full compliance with regulations. You'll hear this term in contexts like internal audits, corporate governance, Or risk assessments. Staying in compliance helps companies avoid legal trouble. All right, let's take a moment to check your understanding so far. We've been using these legal terms. Now, let's match them to their meaning. Here are your terms: counsel, legal standing, liability, precedent, compliance. And here are the possible meanings: legal responsibility for something, a previous decision that guides future cases, to give professional legal advice, the right to bring a legal case, following legal rules or standards. So take a moment and try to match them. Feel free to pause the video and think about it. No rush. Okay, ready to check? Let's walk through them. Counsel. That's C, to give professional legal advice. So instead of saying give advice, we say counsel a client. Sounds more professional, right? Legal standing. That's D, the right to bring a legal case. If someone doesn't have a legal standing, they can't file a lawsuit. Liability goes with A, legal responsibility. Think of civil cases where someone's found liable for damages. And precedent, that one's B, a previous decision that guides future cases. It's a big deal, like we talked about in common law systems like the US and UK, as well as international courts like the Inter-American Court for Human Rights. Last one, compliance, and that's E, following rules or regulations. Businesses talk about this all the time, being in compliance with the law. If you got them all, great. If not, don't worry. We're going to keep using these terms so they feel more natural with practice. Now, let's take that vocabulary and actually use it in some real world context. You'll see 5 sentences, and there are 5 words to choose from. Again, counsel, legal standing, liability, precedent, and compliance. Go ahead and pause the video for a second and try to fill in each blank. All set? Let's go through the answers together. The judge ruled that the plaintiff had no legal standing to sue. That means they didn't have the legal right to bring the case in the first place. Our firm must ensure full compliance with data protection laws, super common in corporate law and regulatory law. It just means follow the rules. The attorney offered clear counsel on the client's next steps. That one's straightforward. Counsel is a professional way to say advice. This case could set an important precedent for future lawsuits. This is what happens when one court's decision influences other similar cases. The company accepted liability for the damages caused. That means they're taking responsibility, legal responsibility, for what happened. So, how'd it go for you? If you got them all, great work. If not, that's why practice makes perfect. So, just hearing and using terms like this will help you get more confident over time. Now, let's take a look at some common modal verbs you'll hear when giving legal advice. We use should when we want to recommend something. For example, you should speak to a lawyer. Must is stronger. It shows legal obligation, like tenants must pay rent on time. Might suggests something is possible, but not certain, like the court might reject the evidence. Can is used for general possibility or ability, as in we can request an extension. And finally, could is great for polite suggestions. For example, you could include a disclaimer. Try listening for these modals the next time you read legal emails or documents. They're everywhere. All right, let's talk about really common idioms in legal and business conversations. First one, cover your bases. This just means to be careful and make sure you've protected yourself. You're checking all the details, thinking ahead, making sure nothing gets missed. So, if a lawyer says we reviewed every clause to cover our bases, it means they're being thorough. trying to avoid surprises later. It's a great idiom to use when you're talking about playing it safe. Next up, in hot water, one you want to avoid, and probably have heard this one before. If someone is in hot water, it means they're in trouble, and not the small kind. Usually it's serious and often legal, like in this sentence. The company is in hot water for violating the contract. This idiom pops up a lot in the news when a company or a public figure is facing legal action or public backlash. This one has a similar tone to it. On thin ice. If someone is on thin ice, it means they're in a risky situation, they've made a mistake or pushed the rules, and now they're close to getting into trouble. For example, the witness is on thin ice after lying under oath. It's like saying, you better be careful, one more mistake and you're in real trouble. We use this a lot when someone's actions have put them in a dangerous spot legally. All right, here's one that I definitely get frustrated with. I know fellow lawyers do too, as well as clients. Red tape. This means bureaucracy. All the paperwork, procedures, and delays that slow things down. You'll hear people say things like, there's a lot of red tape in the visa application process. So, if you've ever felt stuck dealing with forms, approvals, or confusing rules, that's red tape. And last idiom for today, letter of the law. This idiom means applying the law exactly as it's written. No flexibility, no interpretation, just what the words say. So when someone says the judge followed the letter of the law, they're pointing out that the judge made a strict technical decision, even if it feels unfair sometimes. It's a great phrase when you want to talk about how strictly or flexibly the law is applied. All right, now we're going to look at two really important grammar tools that come up all the time when you're advising clients. First conditionals and modals. First conditionals are great for talking about possible future situations and their results, like if this happens, then that will happen. Modals, on the other hand, like you've seen, help us express advice, obligation, possibility, or permission in a clear and professional way. So, understanding the difference between these two will help you give advice that's precise and easy for clients to understand. Let's break down each one so you can see how to use them effectively in your conversations with clients. Let's dive into first conditionals. A first conditional talks about a real or likely situation in the future and what will happen as a result. It follows a simple pattern. If plus present tense, then will, might, or can plus the base verb. For example, if the tenant breaks the lease, they might lose their deposit. This structure helps you clearly explain consequences to your clients so they know what could happen depending on their choices. It's very useful in legal advice because clients often need to understand cause and effect in their cases. Now, let's go over modals again because they're so important. Like we've heard, should, must, might, can, and could. They help us talk about advice, explain obligations, or talk about possibilities. And they show how strong or polite your advice is. For example, you've heard this one before. The tenant should read the contract carefully. This is polite but clear, and it's a recommendation. So, using modals makes your advice sound professional and precise, which is exactly what clients need. So, here's a simple way to keep first conditionals and modals straight. Think about what you want to focus on. If you want to focus on a clear cause and effect, like what will happen if something occurs, then that's when you use a first conditional. But if you're more focused on how to give advice, the tone, the strength, the level of risk, then modals are your go to. Those are what you should use. So, first conditionals is for cause and effect, modals is for tone and advice. So, keep that in mind, and you'll sound really clear and professional when talking to clients. All right, to wrap things up, here's a quick tip to practice. Use a first conditional when you want to explain what might happen next, like a possible outcome. For example, if the contract is unsigned, the deal won't be valid. But when you're giving advice or stating rules, modals are the way to go. Like you must sign before the deadline. So remember, first conditionals for what could happen and modals for what someone should or must do. Keep practicing this and it'll soon feel natural when you're advising clients. And before we finish, let's just pause for a moment and talk about tone, which is so important when giving legal advice. It's not just what you say, but how you say it that matters. Clients want clear guidance, but they also want to feel respected and like they're making their own decisions. And that's where the modal verbs like should, might, and could really help. They soften your message, making your advice sound professional, but not too pushy or demanding. So instead of saying you must do this, you might say you might want to consider this option. So remember, good legal advice is all about balancing clarity with tact. And here's the key insight I want you guys to remember. The way you phrase advice really shapes how your clients feel and how they respond. If you use polite, flexible language, clients usually feel more comfortable. They feel like you're guiding them, not bossing them around. And that builds trust, which is huge in legal work. But if your tone is too forceful or harsh, they might shut down, get confused, or even push back. So always ask yourself, how does this sound to the client? Legal advice isn't about giving orders, it's about helping people feel confident and supported. All right, nice work today. We covered some really important tools for giving legal advice. You practice modal verbs like should, must, and might. Also, we talked about first conditionals, great for talking about consequences. And remember that it's great when you talk about consequences. For example, if this happens, then that might happen. And most importantly, we talked about tone and how to sound clear and professional without being too harsh. Because clients don't just want legal answers, they want to feel supported and understood. So keep practicing these, and they'll make a big difference in how you communicate with clients.